Hello and welcome to LiveLaw Daily, your daily no-noise briefing on the most important legal developments from across India's courts. I'm your host Debujit Das and today is Wednesday of May 27th. We have 8 important stories for you, so let's get into it. So every time you vote in India, a small paper slip is generated inside the voting machine, showing the candidate's name, number and symbol. That's the VVPAT slip, or a voter verified paper audit trail. And a businessman from Andhra Pradesh named Nalla Suresh Reddy has been arguing before the Supreme Court that there's something important missing from it, and that is the exact time the vote was cast. His lawyer, Senior Advocate Devdutt Kamath, told the court that this absence creates what the petition calls a physical audit gap. The argument is that while other electoral records like Form 17A, Form 17C and the EVM control unit each capture different pieces of information, none of the physical paper trail tells you when a vote was recorded. And that, the petitioner argued, becomes a real problem when disputes arise over late-hour voting, sudden turnout spikes, or even discrepancies between electronic and paper records. The petition even cited concerns around the 2024 Andhra Pradesh elections as an example of why such a safeguard matters. Though it was careful to clarify it wasn't challenging any election results, only pushing for a prospective fix. The petitioner also leaned on a string of earlier Supreme Court decisions, including the landmark 2013 ruling in Subramaniam Swamy vs. Election Commission. This was to argue that this was simply a limited, sensible enhancement to an existing system. But today, the bench led by Chief Justice of India Suryakant disposed this petition, leaving the question of whether to add a timestamp on VVPAT slips entirely to the Election Commission of India to decide as a technical matter within its own domain. And from election machines to an election-related law being fought across courts. Our next story is about a fresh legal battle over the rights of transgender persons. Earlier this year, Parliament passed an amendment to the Transgender Persons Protection of Rights Act, and it's been controversial from the start. The 2026 amendment has drawn legal challenges across multiple high courts, with critics arguing that it strips away something fundamental, the right of transgender persons to self-identify their own gender. Now the union government wants all those challenges pulled out of the high courts and consolidated before the Supreme Court. Solicitor General Tushar Mehta mentioned the matter before the Chief Justice of India Suryakant on Wednesday, requesting that the transfer petitions be listed for Friday. His concern was practical, as with more than one high court seized of the issue, there was a real risk of conflicting rulings coming from different benches. But the Chief Justice was not immediately convinced that bypassing the high courts was the right move. Sometimes we can have the advantage of the high court view also, he observed, suggesting the top court may actually want to see how the high courts engage with this issue before stepping in itself. The matter is expected to come up again on Friday. Moving on to Kerala, where a long-running rape case against a former MLA came to a close in a fast-track court yesterday. In 2022, a serious allegation emerged against Eldose Kunnapillil, a former MLA from Perumbavoor in Kerala. The prosecution alleged that he had lured the victim to the MLA hostel at night through repeated calls and messages, taken her to a building near a railway station on the pretext of meeting, and raped her there. On that occasion and on multiple others too. 2 co-accused, Renisha and Sippi Nuruddin, were alleged to have threatened the victim to keep her silent, one posing as a jail superintendent to intimidate her. The case was brought under multiple provisions of the Indian Penal Code, including sections dealing with rape, assault, criminal intimidation and even attempt to murder. But on Tuesday, the fast-track special court delivered its verdict. The special judge presiding acquitted Kunnapillil and both co-accused, finding that the prosecution's own witnesses, including the victim herself, did not support the case in court and turned hostile. With no evidence on record to sustain the charges, the court had no option but to acquit all 3. Staying with criminal law, but this time a conviction being upheld, the Rajasthan High Court had something to say about Asaram this morning. It's been over a decade since self-styled godman Asaram was first convicted for raping a minor at his ashram in Jodhpur in 2013. A special POCSO court had sentenced him to life imprisonment back in 2018, convicting him under a range of IPC provisions including rape by a person in a position of trust, gang rape, human trafficking, wrongful confinement and criminal conspiracy, along with offences under the POCSO Act. Asaram challenged that conviction before the Rajasthan High Court, and today a division bench of Justice Arun Monga and Justice Yogendra Kumar Purohit delivered its answer. The High Court has upheld his conviction and life sentence, though it partially modified the original order. The POCSO convictions were set aside and the gang rape and criminal conspiracy charges did not survive. But the core conviction under the Indian Penal Code, including rape by a person in a position of trust, that stands. 2 co-accused, Sharad and Shilpi, who were sentenced to 20 years, have been acquitted. Now to the biggest constitutional verdict of the day, that is the Supreme Court's ruling on the special intensive revision of electoral rolls and what it means for every voter in India. Over the past few months, the Election Commission of India has been running a special intensive revision of electoral rolls, already completed in Bihar, Kerala, Tamil Nadu, Puducherry and West Bengal, and currently underway in Uttar Pradesh, Gujarat, Rajasthan and a few other states too. The exercise asks voters to submit documents verifying their eligibility to be on the rolls. A group of opposition leaders including TMC's Mahua Moitra, RJD's Manoj Jha, Congress's KC Venugopal and NCP SP's Supriya Sule. All of them challenged this before the Supreme Court. Their argument was that asking people already on voter rolls to prove their citizenship is essentially an NRC through backdoor, the National Register of Citizens. It flips the burden of proof and strips people of voting rights without any formal legal process. Today, a bench of Chief Justice Suryakant and Justice Joy Malia Bagchi delivered its verdict and it largely sided with the Election Commission. The court held that asking for documents does not reverse any presumption of citizenship. It's simply a verification mechanism. The ECI has the power under Article 324 of the Constitution to maintain clean and credible electoral rolls, and this exercise meets the test of proportionality too. That is, it's neither excessive nor arbitrary. But the court drew one firm and consequential line, which was if someone's name is deleted on grounds of doubtful citizenship, that deletion does not make them a non-citizen. The ECI must, within 4 weeks, refer such cases to the competent authority under the Citizenship Act. That authority must give the person a proper hearing, and if they're found to be a citizen, their name goes back on the rolls before the Election Commission. It resonates across India. Shankar Lal served Madhya Pradesh's Home Guards Department for decades, retiring as district commandant in 2001. When his wife passed away in 2017, he did what any parent would. He nominated his daughter Jyoti to receive family pension benefits after him. But the authorities here said no. Their reasoning came straight from Rule 44 Clause 5 of the MP Civil Services Pension Rules of 1976. Under that rule, widowed daughters qualify for family pension. Unmarried daughters qualify, but divorced daughters like Jyoti find no mention. And since the rule did not cover her, the nomination was formally rejected on December 16, 2021. Jyoti then took it to the Madhya Pradesh High Court. Her counsel pointed to a 2013 office memorandum from the Ministry of Personnel. Which recognized dependent divorced daughters as entitled to family pension, also subject to conditions of dependency and income. Justice Vishal Dhagat of the Jabalpur bench agreed and went further with it. He held that there is no meaningful distinction between an unmarried, married or even a divorced daughter. Excluding divorced daughters from the definition of family while widowed daughters remain included is arbitrary, and arbitrary exclusion from a government benefit violates Article 14 of the Constitution, which is the right to equality. With this, Jyoti Srivastav won. Next, we have a story surrounding Assam Chief Minister Himanta Biswa Sarma and his speech that allegedly targeted a community, and a court notice that was issued today. Assam Chief Minister Himanta Biswa Sarma is no stranger to legal controversy, and now a Delhi court has put him on notice again. The trigger this time is a public speech in which Sarma allegedly urged people to trouble Miyas, a derogatory term used for Bengali origin Muslims in Assam, and reportedly claimed that 4 to 5 lakh such voters would be removed from electoral rolls through the special intensive revision process. Activist Harsh Mandar filed a complaint seeking an FIR against Sharma under BNS provisions dealing with promoting enmity, public mischief and outraging religious feelings. But a magistrate's court had dismissed that complaint on April 20th on a straightforward ground, which was the speech was made in Assam, not Delhi. So Delhi has no territorial jurisdiction. Mandar challenged that. His counsel argued before the Sessions Court that under Section 173 subsection 1 of the Bharatiya Nagarik Suraksha Sanhita, a complaint about a cognizable offence can be filed at any police station in the country. That's the principle behind a zero FIR, backed by a Ministry of Home Affairs standard operating procedure. The additional sessions judge at Saket issued notice to Chief Minister Sharma and the Delhi police asking them to respond. And finally, a story that affects lakhs of school children across the country. CBSE issued a circular and some parents did not take it sitting down. If your child is in class 9th this July, this story is for you. In April this year, CBSE told schools something very clearly. The mandatory third language requirement for class 9th students won't kick in until 2029-2030. Schools planned around that, parents planned around that, and even students who had been studying French or German for years had planned around that too. Then on May 15th, a new circular landed. From July 1st, 2026, which was just 6 weeks away from the notice, every class 9 student must study 3 languages, with at least 2 of them being Indian languages. Foreign languages like French and German can be opted for only as a 4th language. And there are more problems too, because apparently there are no textbooks or trained teachers ready. The circular itself acknowledged this, suggesting schools should create an interim arrangement where teachers from other subjects with functional proficiency step in and use class 6 textbooks for class 9 students. 19 parents and teachers from Delhi, Gurgaon, Noida and Chennai took this to the Supreme Court. Senior advocate Mukul Rohatgi, arguing for the petitioners, pointed out that the textbooks don't even exist yet. Senior advocate Kapil Sibal called it a federal issue. Language, he said, cannot be imposed. The Supreme Court's bench of Chief Justice Suryakant, Justice Joy Malia Bagchi and Justice Vipul Pancholi has now asked the Union Government, CBSE and NCRT for a comprehensive response. So there's no stay yet, and July 1st is still the deadline, and the next date of hearing is in the second week of July. That's all for today's episode of LiveLaw Daily. To stay updated on every one of these stories as they progress, visit livelaw.in or check the description box with the list of stories discussed today. We'll be back again with our next episode with the most important stories, so stay connected to LiveLaw to stay updated with everything that is law.